Any mention?
I'm praying for some unlisted matters tomorrow.
Which one?
Same SOP matter.
Same matters. Why unlisted?
Because the date of 45 days which has been set in the OML is expiring during the vacations.
During the week?
During the yes.
They are already filed.
Plus 6 for tomorrow.
Yes.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 73. Your Lordship, as per the last order, we were supposed to file an additional affidavit. I'm praying for some more time, Your Lordship.
Why? Then we will close it. If we have posted for hearing and then you file Karanda Kanta Rava.
Yes, Your Lordship.
Why? What additional affidavit?
Your Lordship, we had sought some instructions regarding the petitioner had brought on record that some teachers who did not have B.Ed were also appointed, Your Lordship, to the post.
When was the last order passed?
Last order. 1610, Your Lordship.
Okay. After 2 weeks, yes, on the prayer. So to file as an affidavit, yes.
Obliged, Your Lordship.
Obliged, Your Lordship.
I place, Your Lordship. Your Lordship, item number 67, Your Lordship. It's a joint prayer.
My lord, this is a rubber plantation where they have to.
What happened?
There's a settlement, my lord. They're applying for consent to operate, my lord.
Okay, after 2 weeks.
Deeply.
Lordship, I beg to mention item number 70, Lordship. I am praying 1 week time, Lordship.
Why? You have objection?
No, Lordship.
Okay, yes, 2 weeks. Yes.
Lordship, I beg to mention item number 75 for 2 weeks, Your Lordship.
No objection.
Yes, 2 weeks.
May it please, Your Lordship. Lordship, I beg to mention item number 68. My lord, I'm praying for 2 weeks' time.
Continue, Laka. It's lucky. What is this?
That
Other
RTI
side
matter, my lord.
Huh?
RTI matter, my lord.
Who's the other side? You inform them.
Lordship, I'll do.
You've already informed them.
I'll inform them.
No. They will call down. That is a practice in this
Wait,
court.
please, Lordship.
Unless you inform them, no, yes.
Lordship, I beg to mention item number 72, Lordship. I've already informed the petitioners, Lord. This matter can come up after 1 week,
Please, Your
Lordship.
Lordship, and for the
Why
petitioner.
do you repeat a journalism matter?
Lordship, we have some difficulty to
What
deal with.
difficulty? Because you change counsel now. How
No,
long?
Lordship, I'm for the respondent 5, Lordship, and we hardly take any attorneys.
What about
We
you?
will usually.
For respondent 3, Lordship.
Why? Take a adjournment also.
No, Lordship.
Ready to the matter? Ready to will do it then.
Lordship, let it come for a week, Lordship, because we have some.
You ready with the matter?
Yes, Lordship.
Your
Yes.
Lordship, no objection to the prayer.
After a week,
Your
Lordship.
Lordship, there's an interim order as well. Pray for
1 week,
extension
yes.
of the same.
Deeply obliged.
Highly pledge, Your Lordship.
Upon reply of respondent. So respondent, interim order to continue.
Highly pledge, Your Lordship.
May it please Your Lordship. Your Lordship,
Yes.
I beg to mention an unlisted item. Your Lordship, I seek liberty to submit this mentioning memo for it to be moved tomorrow. Your
What's the
Lordship,
matter about?
Your Lordship, it's a tender matter which we apprehend will proceed to our exclusion. We are an intending bidder.
What tender for?
Tender for aluminium sheets, Your Lordship. It was
Roofing material.
Sorry, Your Lordship.
Roofing material.
Yes, Your Lordship.
Yes. Okay. Tomorrow.
Great.
Item number 1.
May it please, Lordship. Lordship, item number 1 and 2 are identical matters, Lordship. The SOP matters. Petitioners, those memorandum dated 25th September, Lordship. The petitioners
When
have
the
been
matter listed now?
14th, Lordship.
14 November.
14th November, Lordship.
Oh, it's similar order.
12th, Lordship.
You first is Pandey, then council. Who's for the state? Nobody. Then council petitioner. None appears. We have a state respondent. Stop as this matter is connected to so and so, listed on same order next one.
Interim protection, Lordship, I'm praying. Lordship.
Same order will come like that. Contempt 438.
Item number 3. Item number 3.
Yes. Who's for the petitioner? None appears not a petitioner. When the matter is called out, list after 1 week is.
4.
Or two. List after 1 week.
May I
Yes,
please,
Mr. Chaudhary.
Your Lordship, this is actually for pensionary benefit, my lord. So, Your Lordship has passed an order earlier directing the representation to be filed. This is page number 33, Your Lordship.
Which number?
33. Against the respondent.
You filed representation?
Yes, Your Lordship. This
What
is
was dated when?
page number 31, Your Lordship.
Who's appearing for the MECL? No one's appearing.
No one is appearing, Your Lordship. This is the third application, Your Lordship.
When did you file a first representation? But the
Representation.
last order says that it says that MSR Kohli submitted no such representation has been filed.
No, this is the first one actually. She submits in the second application. She filed that, but thereafter I filed, Your Lordship. Please come to the page number 31, Your Lordship, along with their signatures. It is their seal and signature.
Yes, sir. Current Chabri response to the petitioner. I should notice you are for state.
Yes, Lordship.
Yeah,
Respondent
for
number
whom?
1. Respondent number 1.
Mr. Pala is present with her for number 1. Notice issue to the remain response within 2 days. Stop this matter is submitted by Mr. N.H. Chaudhary. This matter is the third round litigation and involves the disposal of the representation filed by petitioner.
Dated 30th July, my lord.
Dated
30th July, 2024.
2024, which till date has not been attended to. So, this is matter after 2 weeks. We take steps.
Order. Obliged, Your Lordship.
Item number 5.
Yes.
Please, Your Lordship.
You see what's happened to your petition? Your 3 and 4. How many responses are there? In the
Yes, Your
main
Lordship.
petition?
There was so because of the implement of the new parties, Lordship. So we have to amend the cause title accordingly, Lordship.
No. They'll come as respondents. See in the minute petition, the respondents. How many respondents are there? Are it?
2 respondents and 3,
1
4, 5 of performer.
Performer, Lordship.
1, 2, 3, 4, 5.
Yes,
right.
Lordship. Yes.
So you should write application accordingly.
Yes, Your Lordship.
There was withdrawal and file a fresh one.
Yes, Your Lordship. I'll do that. I apologize,
The
Lordship.
LCM submits due to the defects in this case. We are going to withdraw the same to file a fresh if praise allowed. You have to make it clear in the application.
Yes, Your Lordship. Deeply obliged.
Item 6.
Yes.
Is it item number 6, Your Lordship?
Yes.
Your Lordship, I am appearing on behalf of Dr. Saraf in item number 6, Your Lordship.
Yes.
I pray for an appointment in the matter, Your Lordship. Dr. Saraf is on X before the Guwahati High Court in some partnered matters.
Doesn't matter. It's for admission hearing today.
Lordship.
Yes,
Lordship, let it come on the 12th.
You are Niyam Datta on Niyam
Yes, Your Lordship.
on the Mr. Datta. So on behalf of Dr. A.K. Saraf, who's not available at the moment. This matter after 1 week.
Much
On the
about
12th, okay, 12 November.
Much about
7. Item 7.
Please, my lords.
Yes.
Also on the last date, your lordships was pleased to give 1 week time for the purported issuing of a corrigendum to the charge sheet.
It's been issued.
But nothing has been.
It has not been issued, my lord.
Then
But the instruction says, my lord, because this has to go to Defense Minister, my
it
lord.
doesn't matter. Then you have to go ahead with your defective show cause notice.
No, my lords.
None of charge.
My lords.
But the process has been initiated, my lord. It will take only a matter of time, my lord. But otherwise also they've come with memorandum of charge, my lord. Except that, because I'll place several reasons, my lord. At this stage, the lord will not interfere in the matter, my lord.
No, but whatever it is, we not yet come to the meat of the matter.
My lord.
The only thing is that you have to, what you sought was correction within 1 week. Not been done. So what are we to do now?
Well, even without that, my lord.
We can, the matter can be heard.
Because that will take some time, my lord. If you also please to grant me some, maybe another 2 weeks time, my lord. But they're saying that even 2 weeks, it might take a little more than 2 weeks also.
2 weeks and to get the corrigendum
My lord.
or to prepare.
It is just approved by the Defense Minister. My lord.
Whether the corrigendum can a matter be taken forward for this different hearing today? Correct.
Yes, ma'am. For the maintainability, I'm raising this question.
Ready today.
Actually, I'll pray for 2 weeks time. We'll try to expedite the corrigendum can be issued. But it's not a case that there is no dereliction of duty. There is a dereliction of duty. Only because the memorandum is not been framed very properly. That in itself will not be a ground to set aside, my lord. A law is well settled, my lord. Only in very limited grounds at this stage, my lord, you also will interfere in the matter.
No, of course. That is why you want to hear an admission hearing.
Yes.
Corrigendum will take 2 weeks, you say?
No, my lords, I have one submission, my lords.
Yes.
My lords, I think this is the 4th or the 5th time, my lords, would appreciate.
Objection only last time.
Yes, my lords. And my lords, even in that case, my lords, may I just demonstrate even a corrigendum will not come to the rescue of my lords proceeding with this matter. My lords, this is a case in which I have primarily, my lords, also challenged the issuing of the charge sheet, not just of the on the ground of allegation being vague and unspecific, my lords, and not existing. Also on the ground that the requisite notifications, regulations have not been adhered to before the issuing of the charge sheet. But I have several grounds, but may I just come to the most important issue, which has to.
Important ground?
I'm sorry, Mats?
Which is your most important ground?
Mats, the charge sheet in the present case, in the backdrop of the facts, could not have been issued without the first stage advice of the CVC. Mats, the notifications are on record. The facts that have been disclosed in the charge sheet are in the nature of that the integrity of the petitioner is doubtful. What's the second fact in the charge sheet is that this is an allegation of 2023. Admittedly, the charge sheet comes to be issued in April 2025. But there is a delay of 2 years. But there is a CVC notification which says that in cases where there is a delay, it will be deemed that the vigilance angle is involved and CVC first stage advice has to be taken. That's the first thing. Second, Manoj, the same notification says that
in writ petition, the pleading.
It is a part of the record. And Manoj, the second says that whenever the integrity is doubtful, in that case also the first stage advice of CVC has to be taken. But the third thing is in the respondents themselves in their counter affidavit says that this is a matter which is being overlooked by CVC. And Manoj, also in the fact that I have already filed a whistleblower complaint in 2022 July. When they were initiating a court of inquiry, the CVC issued a letter to them, don't victimize the petitioner, all the actions have to be kept in abeyance. That also is on record, Manoj. But when these facts come, may I just show that notification for a minute? But I'll start by showing page 91 of the writ petition. This is, my lords, letter issued by the respondents themselves on the CVC letter, 18th October 22. Has your lordships got that?
Yes.
COI ordered wide ADGBR so-and-so, wide their convening order so-and-so, dated 23rd September, may be kept in abeyance till further orders. This is only on my whistleblower complaint, my lords. Now your lordships may kindly have the notification, my lords, of the CVC. Lords may kindly have page 199.
Yes.
Now, words, page 198 is the amendment. 199 incorporates that. Vigilance angle definition of, your lordships has the 13th April 2004 notification by the CVC minutes. It says Central Vigilance Minutes, has got it in the top.
Is modified. 2005 modifies this 2004.
But this was modified Merge may have the 198 page office order of 21st December 2005.
Delay disposal of a case perceived after would infer the conclusion.
Yes. Now, may I just read the relevant part?
Yes.
Para 2A at the bottom of page 199. Yes. There are, however, other irregularities where circumstances will have to be weighed carefully to take a view whether the officer's integrity is in doubt. Gross or willful negligence, recklessness in decision making, blatant violations of systems and procedures, exercise of discretion in excess where no ostensible public interest is evident, failure to keep the controlling authority superiors informed in time. These are some of the irregularities where the disciplinary authority, with the help of CVO, should carefully study the case and weigh the circumstances to come to a conclusion whether there is a reasonable ground to doubt the integrity of the officer concerned. Now, my lords, may kindly have the next page. Any undue, unjustified delay.
2B has been amended.
I'm sorry, my lords?
Is amended 2B.
Yes. Yes, my lords.
By your page 190.
Yes, my lords. That is why I'm just reading this, my lords. But any undue, unjustified delay in the disposal of a case perceived after considering all relevant factors would reinforce a conclusion to the presence of a vigilance angle in a case. But this first stage CVC advice has to be taken, my lords.
Yes.
Now, my lords, when there is integrity involved and when there is a delay, the my lords may kindly allow me to show the SOP of the respondents themselves as to what they have to say when the disciplinary proceedings have to be initiated. But it starts from page 201.
Yes.
Has my lords got that?
Yes.
But page 201 is the starting page. 202, my lords, may kindly come to. I'll take a minute, my lords, and just give an overview to my lords regarding the manner in which the disciplinary proceedings have to be conducted and also the timelines. Page 202 for a minute, my lords. Main stages of disciplinary cases. Has your lordships got that?
Yeah.
The first stage is establishment of a prima facie case against an officer and issuing of a charge sheet, conducting oral inquiry, and third is imposition of penalty. My lords, may kindly come to page 203, point number 10.
Yeah.
Has your lordships got that? Point A. In case of doubtful integrity, composite case of all blameworthy officials of all categories are required to be sent to MOD for obtaining the first stage advice of CVO.
So your contention is never done.
In the respondents, they have said that it is not required. But they have admitted in the counter affidavit that this is not required to be done. We have not done that. Now, my lords, I may buttress this point further, but there is one more point I can show on the same page. But page 203, first point, clause C, framing charges. What's charge has admittedly been framed against me. The SOP of respondent says, frame the charges properly and check whether the COs were found blameworthy in the preliminary investigation. There has to be a preliminary investigation and the replies given by the CO's witnesses led to a prima facie case against them. The documents which are proposed to be listed in the charge sheet should be scrutinized before identification. Notice, I just pause here for a minute. One, admittedly in the counter affidavit, it has been said that no preliminary investigation has been done, whereas the language says it should be done. Two, my lords, the purpose of this preliminary examination is to ascertain whether the charges would stand the scrutiny. This is a case where the respondents have categorically themselves said that the wordings in the charge sheet are not proper. Now, my lords, may kindly come to.
It means they are violation the own SOP.
But they are violating. My lords, I can show at least 17 clauses within this SOP which has been violated. My lords. Now, may I just show one very important thing at page 206 of this SOP itself. It has clause 16.
Yes.
Responsibilities and time frame. Time schedule laid down by government for various activities is as under. Detection establishing lapses prima facie progressing draft charge sheet 8 months. But in my case, the show cause notice is of 27th June 2023. Issuing of charge sheet within 2 months. But in my case, the charge sheet is issued on 22nd April
Are
2025.
what is SOP directory or is it mandatory?
But it is respondents,
Whatever
SOP.
it is, but is there any
But in my view, it has to
how
be.
flexible is it? In other matters, have they followed this stringently?
But
Suppose in other similar matters where this BRO, whatever, GREF has undertaken these proceedings, has it been by this book, by the SOP?
But the only thing I can say in my case, they seek to enforce this by the word. That is why I have been issued a charge sheet, Manoj.
Right.
That is the only thing I can come to, Manoj. I am not a privy to the other DE proceedings, but in my case,
yeah, well,
Manoj, may I just read one more line? Manoj, just to conclude this, Manoj, and then I'll leave it to Manoj. But the appointment of IO and PO to be done within 2 months.
yes,
In my case, the charge sheet is issued on 22nd April 2025. Reply is received on 9th of May 2025. But today we are in today we are in November, my lords. Within 2 months, they had to appoint an IO. In the counter affidavit, the stand which has been taken is that the reply is under consideration. It is a premature writ petition. 9th of May, they came to know that the charge which has been framed cannot even stand on its legs. It is not a case of non-submission of IO report. 9th of
that is admitted.
No, I am not on that.
That they say they will issue.
No, why I say so?
Yes.
Because this is a case of victimization. This is a case of series of victimization ever since my whistleblower complaint has been filed in March 2022. Once I was transferred in May 2022, premature transfer. Not an administrative transfer, punishment transfer. At the time, I was serving as inquiry officer in 5 Ds. This is only for 3 Ds. I was at that time serving as inquiry officer in 5 Ds. I am transferred. Thereafter, a court of inquiry is issued against me.
Yes.
That court of inquiry, I stand discharged. Again, a second court of inquiry is initiated on the same charges. That time, CVC comes to the rescue and directs the respondents, don't victimize him. Everything is kept in abeyance. The matter stands closed there, but the respondents did not stop. They refused to allow me to go on deputation. They refused to give me an NOC. But while that refusal is done, my integrity is challenged.
These are
But may I just
irrelevant to the budget proceedings,
I'll show why they're relevant. I'll show, sir, I'm so sorry. May I just show why they're relevant? But while I challenge that in the High Court says 3 things. The petitioner is an officer of competence and unimpeachable integrity. The action of the respondents is unjustified and arbitrary. And the third thing, Manoj, which the honorable courts, Manoj, at the time of argument says that you have initiated a court of inquiry against the petitioner. And you have said that he appeared in the interview without any authorization. Once the High Court was to give an adverse finding, the counsel for the respondents in that case categorically said that we will not proceed with this. The matter rested, Manoj. I can show 4 places in this counter affidavit before the Honorable Court wherein, despite giving a statement in the High Court, the respondents have again reinitiated that petitioner has done a deceptive activity. He has lost the case in High Court. He appeared in the interview without any authority. That statement is already settled before the High Court. What they do is they issue me a show cause notice. Then they issue me a charge sheet. This is a victimization which is happening, and this charge per se cannot stand. Why? I'll just show that. May kindly have page number 158.
When is the promotion due?
My promotion is due next year. DPC and I have been.
No, I'm not.
I have been informed. I have been now informed. Why the delay in the present case is. I have been just informed that probably the names have already went. The only intent is that before the DPC takes a decision, the charge sheet should be there. Somehow the petitioner should not get promoted. This case cannot stand on its legs. May I just show one more thing now?
Next promotional post is what?
For the post of Chief Engineer, this is my last promotion which would be due before I retire, And this is now I'm so obliged asked me that question. This charge sheet comes to be issued on 22nd April 2025. The question is why after 2 years? The answer is in the writ petition, 18th April 2025, 4 days before the issuance of charge sheet. I file a complaint in CP Gram for some of the illegality which has been happening in the organization. 4 days within that complaint, once I received this charge sheet for a serial number which is of 2023, page 71 for a minute.
Now that you've seen earlier on. Yeah.
But serial number 2023 for a charge of 2023, my simple question is, what's the department which has been made for construction of roads in border areas and sensitive areas? Would the effort of that department would be to curtail the freedom and the free environment for officers of civilian nature, or would it be directed towards the national interest? All along this has been a story of army versus civilian. BRO is organized group A civil service, central service. The officers from army, they come on deputation for 2-3 years and they take these decisions just to harass the civilian officers. This charge sheet cannot even stand. No preliminary investigation done, no CVC first stage advice taken. The CVC advice is also not taken.
Number one, preliminary inquiry is essential. Number two is that advice of CVC is also required. And the third one is saying that the charge sheet was issued within 3 days after you made the complaint.
4 days after the complaint.
4 days after complaint.
And one more thing, my lords.
Okay.
Why this charge sheet has been issued is as
why do you say the old file number? 2023.
Yes, because the moment I mentioned the old file number,
just now that they use the old file number.
This is a part of record. Yes. Why I'm saying so much, I did not argue this till now. I'm getting the opportunity, to place this point right now. Why I say the old file number, had anything transpired between 23 and 25, it would have reflected in the charge sheet. They kept sitting on this for 2 years. The moment I file a complaint and the moment the promotion is due, they specifically timed the issuance of charge sheet to a point where the promotion can be hampered. That is my argument in the repetition.
That's why it took out old file number.
I'm sorry, Mats?
That's why your allegation, the allegation is that. That's why it took out old file number, because nothing happened between.
Yes, absolutely. In the counter affidavit also, they have said nothing as to what happened between these 2 years. In fact, my lords, counter affidavit, page 36, they say, in this while we have even got no record of the correspondence between petitioner and disciplinary authority. They don't have records. On what basis will they conduct the inquiry if they want to conduct? May I show that page, my lords?
No. Yes, Dr. Mojika.
My lord, he submitted inquiry reports in June 2024, my lord. So where is the question of delay of 2 years, my lord? It is submitted in 2024. Memorandum is issued in 25.
25. That's also after 1 year.
Well, kindly see, because after we received the inquiry report, we have to act on the inquiry report first, my lord, rather than taking action or going after him. Submitted in June 24, my lord. So delay crystallizes then only, my lord, after he submits.
But this is correct what he has submitted, that you have not gone, there's no preliminary inquiry done.
Well, I'll answer that.
Integrity of the officers in question, that the CVC is advised necessary.
But I'll just place this office memorandum, my lord. Second copy.
These are new guidelines.
This is 20.
But this is not your SOP.
My lord, these are the DOPT OM, my lord. 29 November 2012.
No, but the SOP shown by counsel the petitioner is different.
But this is 2012, my lord. I'll just point out one paragraph.
It's going to get a copy.
I'll give you.
If vigilance angles involved in complaint, the case should be referred to CVC for the first stage advice within 1 month.
If vigilance angle is not involved, case should be put up to disciplinary authority.
If vigilance angle is not involved, case should be put to disciplinary authority. Now his contention
there is no
is that there's the integrity is involved.
Well, I'll take a lordship to the entire memorandum of charge. My lord, nowhere there is any aspersion on his integrity or anything, my lord. It only says, and it is very objective facts, my lord. You are interested in inquiry on so and so date. You submitted inquiry report within so and so date. Well, all documented, my lord. Everything is documented in this.
Where is it?
Page 72, my lord.
Of the petition.
Yes, my lord.
Yes.
First para I may skip, my lord. Second para, as per time prescribed under sub rule 24 or rule 14 of CCS so and so, as amended so and so so and so, departmental inquiry proceedings were required to be completed and submitted within a stipulated period of 6 months from the date of appointment order received by the IO, and additional time not exceeding 6 months for completion of the inquiry at a time. Although Sri so and so so and so so and so had confirmed the written brief of all the 3 departmental inquiries were submitted by the presenting officer Sri so and so on 23/6/22, however, Sri so and so has failed to submit the inquiry report even after repeated reminder issued to him by Chief Engineer so and so by the above act Sri so and so so and so.
Page 74, my lords, it is mentioned.
My lord, we have not said in the article of charge anything about his integrity. My lord.
What's page 74, para 8.
And there is no vigilance angle required, my lord, in this.
Page 74, para 8, fourth line from the bottom. That is, my lords, the statement of articles.
My lord, that is integrity in a different context, my lord.
How will be the context?
My lord, financial integrity is one aspect, my lord.
But does not specifically say SOP financial integrity.
Yes.
My lord, vigilance is always connected to financial integrity only, my lord. CVC has nothing to do with other integrity, my lord, or moral integrity or his official integrity, my lord.
What about this clear from 3 letters, so and so? He had completed in conduct the proceedings.
I've shown this. I've shown this. Page 74.
When he submit them? Inquiry
18th of
report?
June 2024.
June 24.
3 inquiries.
3 inquiries.
He submitted on 18th June and 20th June, my lord. 24.
Yes.
Lords, may kindly have.
We need more detailed hearing.
My lord. My lord, this is not a case for.
Lords, may I just show one thing? Page 157 for a minute.
We'll do one thing. We'll do one thing.
Page 157 for a minute.
We take a date, we'll dispose of that day.
Lords, page 157 for a minute.
Yeah. Because the bench has to break also now for a while.
Page 157 minutes. For a minute. Has your lordships got 24th May 2023?
Yes.
Para 2. In a recently filed counter affidavit in Honorable High Court of Delhi, in which you are one of the respondent, department has cast aspersions on my integrity and stated that I did act unbecoming of undisciplined.
This is your letter.
No, Manoj, I just want to, Manoj, may kindly give me 2 minutes, Manoj, I'll just show what I'm saying. And court of inquiry was convened long time ago in the month of July 22 to investigate these. But knowing well the department stand, you keep on writing me reminders to complete departmental inquiries without giving a thought whether an officer whose integrity is alleged under doubt by department can continue with these. It is also stated in the counter affidavit filed by department that my mental stability is doubtful. It may be informed whether I can continue with these in my alleged present condition or not. Once 8th of May 2024, the High Court says my integrity is not doubtful, and within a month I dispose of the inquiry reports, Manoj.
No, we'll examine it.
What I pray the matter will be taken after 2 weeks.
I would request your lordships, Manoj, if your lordships can take a view today, Manoj. Manoj, there is nothing more left in this case, Manoj. Manoj, they have already said that Manoj, the charge sheet is not worded properly. What's the judgment of Supreme Court on this point, Manoj? I may just say, Manoj,
no, that goes against them, Mr. Gupta. Yes, of course. That they have admitted now that the charge sheet has not been worded properly.
That's my only submission, my lord.
Well, what I submitted, only wording is not correct, my lord, but the allegation is on delayed submission, not on non-submission.
Substantial, then doesn't matter, then we'll hear it.
Much may kindly
fix it after 2 weeks, my lord. In the meantime, we'll expedite it, my lord, and the matter can finally dispose of, my lord.
Yes.
But Mads, if your lordships can consider it today, Mads, I ultimately am in the hands of my lords, my lords.
But we have difficulty also. Yes, sir, Mr. N.K. Gupta, right? Yes, then counsel with the petitioners of also Dr. N. Mozika, Leonard DSGI. The matter has been heard at length.
Not do it today.
On the issues have been raised with regard to the question of whether there is requirement of advice of CBC or preliminary inquiry was held. This matter is substantially admitted for further consideration. It's also submitted by Ms. Dr. Mozika that the corrigentum to the charge sheet will be issued within.
In the process,
in the process of being issued. So in this situation, you take a date. This is matter and so and so. Yes, don't take time next time.
Would consider keeping it next week, minutes or?
What do you take a date? You consult with him.
What 17th?
He wants 2 weeks, so we'll
17th November is 2 weeks, minutes.
2 weeks, yeah.
17th November. May just come on order sheet that it is for final disposal.
It came last time, but then you never know. Advocates week.
I understand that much.
It depends on you too, not on the court. Who's ready?
Item number 8.
I can only request my.
Can only request your senior, yes. Then next day, before next day, request him nicely.
But item 61 is also between the same parties, Manoj. If your lordships can consider.
On that same day.
But no, I have one submission to make. Counter affidavit, Manoj. The respondents took 3 weeks time. Your lordships was considering.
And the other matter.
Yes, Manoj. And
we'll pass orders, then we file it.
But it doesn't happen, my lord. Does it happen in Delhi? I don't understand. The affidavit is filed on the next date. I don't know.
No, not filed next date. Because the main matter is this one.
Fresh matter will file in the month of August, my lord, and they're pressing to the hilt, my lord. That's not done.
It may also be kept for arguments.
Yes.
What's the counter affidavit?
The other matter will take time, my lord. Other matter, I need time.
This matter will take. This matter will post arguments. The other matter will see. Yes.
May I just make one submission in that case?
Yes, Mr. Gupta. 17th. Yes. Next matter.
Oblige, my lords.
Yes. Yes.
My lord, we have
other case disposed of.
Yes, my lord. In East Khasi Hills, my lord, now there's only 2 matters are pending, my lord.
Where's the chart?
My lord, I have filed a report, my lord, on the 30th of October, my lord. I have filed one report, bringing the list of the cases pending.
To this report pursuant to the order of this court dated 2/9/2025 since been filed. As per the report, it is seen that
My lord, North Garo Hills report has come.
yes,
So from the CIS of the High Court, my lord, we came to know that a new district has a case, my lord, pending in respect of ex-MLA, my lord. So that I have enclosed.
in respect of
My lord, in North Garo Hills, Mendi Pathar, my lord. So we
where's
came.
that one in
My
your
lord,
chart?
this is a copy of the CIS, my lord. So therefore,
No,
we
in
have.
your chart.
Yes, my lord, I have mentioned at the bottom, my lord. That's
No, no, on this one.
North Garo Hills, my lord.
Here you've given East Khasi. You have given
East Khasi Hills. East Khasi Hills now 2 pending, my lord.
Which one's been disposed?
My lord, dispose is at page number. This was page number 4, my lord.
It's been disposed of. Oh, because the judge of the High Court.
Yes, my lord.
Yes. Yes. Promise. You've seen that in East Khasi Hills, at present they are
2, my lord.
2 or 1 now.
My lord, 3 it was. 1 got disposed. 2 is pending.
Yes, sir. Oh, yes. Thomna. Total of 3 cases, 1 has been disposed of, and 2 are pending. West Garo Hills, the number remains the same, that is 2. As also with Chaintail Hills. Stop. MSR only submitted that another. Which one?
My
You've
lord,
not given any details here, but
I have given, my lord.
where?
My lord, may kindly have page number.
Not Garo Hills?
Not Garo Hills at page 28, my lord, annexure D.
Yes, then how many? That no party's name is not shown here.
No, my lord, because there are 8 respondents, so he seems to be one of the respondents, my lord, out of the 8.
POXO case?
No, my lord, it is not a POXO case. It is a case under assault, my lord.
Assault?
Yes, my lord.
Who against which?
Because, my lord, we received this from the CIS.
Against which? What's the name? Which MLA? Which MP? Or which?
My lord, if lordship will have this one, my lord, this is from the CIS of the Honorable High Court, my lord. So we came to know from.
In your report, at least the name of the party is not here also.
My lord, it is there, but he is one of the respondent. We came to know through the CIS only, my lord. The bottom one, my lord.
Former MLA.
Yes, my lord.
Okay, Thomna. Yes, OMSR only submitted that this is 2007 FIR.
Yes, my lord.
Then?
My lord, we are also quite surprised because this information has not come from the registry. Basically, we were updating the CIS, my lord.
Then have you got information from North Garo Hills?
Yes, my lord.
Pending?
Yes, my lord. At page 28, my lord, if I have, we have tried to get in touch with. Yes, my lord.
Inadvertently, one case which is of North Garo Hills is still pending. At what stage?
My lord,
stage.
As per the
Against the
PP's
former
report,
MLA.
my lord.
Stop. Those not understood as how this matters escape the notice of the council. However, you sure still pending?
My lord, I have taken. If lordship will kindly come to page 28, my lord, that would
I'm
clear.
on page 28.
My lord, then at 29, my lord, the GR case number is this, my lord. So we have checked the CIS of the Mendi Pathar court, my lord. So we have checked the array of parties. So this name is reflected, my lord. The former MLA name was reflected. So my lord,
We record an order now only.
my lord, we even have spoken to registry, my lord. This actually information has come from the computer department, my lord. Even the registry does not have any record on this. So we have to speak to the PP, my lord.
How which is registered also against a former MLA as one of the accused. Stop. She is, however, directed to obtain specific instructions with regard to status of the case before the next date.
Lordship.
Yes.
Lordship, initially, lordship has passed an order all the district courts to furnish the report with regard to pending cases.
So you this one you find it out personally.
My lord, this has come from the registry, my lord, from the computer department. So we have
you kindly get from your public prosecutor, whoever is there, who was dealing with this case, then we'll know. Yes, with regard to the status of the said case stuff. This is matter after 4 weeks for fresh status report. How is it possible? 2007.
Question number 9.
Yes.
May please, Your Lordship. Your Lordship, the AG, the Advocate General, is currently not available today. This matter can be tagged along with the other transfer
What about
matters.
this your service?
Your Lordship, we have taken steps, but return unsubmitted. We have filed. It has been served, and affidavit has been filed already. As for the last order, also it has been reflected.
When's the matter fixed?
12 November, Your Lordship.
Yes, please that matter listed together with other connected matters listed on 12 November. Praise aloud.
Much obliged, Your Lordship.
10.
I'm praying for 2 weeks' time.
We're supposed to take instructions.
2 weeks further time allowed.
11.
Similar orders.
12. Item number 12.
See, here I was supposed to file the agenda affidavit.
You won't file anymore.
1 week time, you see. Just it is nice from Montreal.
1 week further time is paid for joiner.
13.
Please, Your Lordship.
Yes.
We filed an affidavit.
Yes. They've just filed affidavit. Who's your local counsel?
My lord, I'm online.
No, where's the local counsel? You have served a copy in Mr.
Your
Patak.
Lordship, we've already served.
Have you received a copy of the affidavit?
No, not yet, my lord.
We've served them last week, Lordship.
Yes. You listed after 2 weeks for a joinder of any. Yes. After file.
Already decided. They have
Doesn't matter if you want to file a joinder file, otherwise you come, we'll dispose it of. Yes, affidavit has been filed by the state, by the union respondents, just after 2 weeks for further orders. Yes. Yes.
14. 14.
May we please your lordship? Your lordship, I have given earlier to counsel that is a CM and his daughter can dispose of that after the notification. Clause 7.
Is a missed case.
This is a missed case in the WPC number 201. If they agree to issue the NOC, that matter can be closed down.
You'll issue the NOC now?
Yes, yes, in consultation with the daughter.
Yes, that is the only issue, my lord.
As per the order dated 25th September 2024, the order I have enclosed. Translated copy I have given us.
1 second. Where is that in your affidavit?
No.
No, they have just given a copy of
You given a copy. That was just.
Yes.
Clause 7, Your Lordship.
That means it seems he must have not issue any NOC in Majai. That means
without a consent of the executive.
it's about of Sora or of
Sora.
That means both of them. In other words, if you read 6 and 7, my lord.
Yes.
Sardar Majai shall not issue
Residential
any
certificate.
residential certificate to a non-Khasi without
approval. It works count with.
Here
But
and
is
his
the
executive.
scheme there now?
He expired on Friday. I'm sorry. Your Lordship.
Huh?
Yes.
Friday he expired. Here.
That's what I heard.
Yes. No, I think they will elect new one. I think immediately.
No, they elect one, but then
No, as per this notification.
well, who's acting? They'll have to appoint.
CM Khanna is they have to appoint. I think something.
We'll hold it over for 1 week. These matters. You take instructions, Mr. Lindo.
Yes.
As submitted that the incumbent.
Friday.
Freeman Singh CM Sora expired on Friday. This is matter after 1 week. That's what I was wondering. That's why you didn't see anything.
It's on Friday actually.
57.
Yes.
57.
Please, Your Lordship, I'm praying for some more time in this
Why?
matter, Lordship. We've not received instructions.
What's the matter, Mr. Jha?
My lord, it is with regards to the appointment in the Assam, my lord. Recruit radio mechanic.
2 weeks only. Huh? Weeks for the time as paid, yes.
58.
May it please Your Lordship. Your Lordship, I may be allowed some more time to file my affidavit.
May I please, Lordship? Lordship, I'm entering the appearance for respondent number 5.
5. Yes, Mr. Coach, that represents in behalf of number 5. As such, this notice is complete all respondents. Just after how much time?
3 weeks time, Your Lordship.
3 weeks time.
We've not received instructions as
2
yet.
weeks time as per is allowed. On behalf of the next line, MS T. Yang is also please allowed for the 2 time file affidavit. Praise allowed. The court of none appears for petitioners.
59. Oblige, Your Lordship.
May it please your lordship, I have received instructions on the matter. I'm praying for 2 weeks' time to file the affidavit.
Yes. Yes, Ms. SN, please go allowed for 2 weeks time file affidavit.
Oblige, Lord.
60.
Yes. Where's the petitioner?
She got her relief, Lordship.
So he disappeared also?
Yes, she's disappeared, I guess. Except for that amount in controversy, Lordship, she's at liberty to deal with her account anyway, accordingly.
But there must be some different kind of approach to these matters. Now there are quite a few matters where some
Yes, Lordship.
unknowingly
And some have not even approached this honorable court also, Lordship. It's
unknowingly
happening.
they have been frozen. Yes.
Yes.
None appears for the petitioner in person. The petitioner person is not present today. Submitted by MS NG Shilla that the petitioner has since been allowed to operate her account.
Lordship.
Stop. However, this is matter tomorrow is.
Much obliged, Lordship.
61. Connected.
It's not connected? Oh, this is on 17th.
62.
Please, Lordship. Lordship, we have not received any instruction in this matter. Still awaiting.
Who's appearing? Advocate General?
Yes, Lordship.
Why not receive? What's the matter about? Regarding admission?
Yes.
Yes, that as per the merit list.
Yes.
When are you going to file affidavit?
Lordship, after 2 weeks.
1 week's time, yes.
Lordship, 2 weeks, Lordship. We have not received.
Doesn't matter. Then we'll ask officer to come here and just give oral instructions. Then we will pass orders. Yes, MSS Lalu submits that he yet to receive instruction. Stop. Though some instruction stop. Interest of justice for the 1 week's time is permitted. Yes. You receive instructions or file affidavit.
Lordship. Much obliged.
63.
Yes, notice you are appearing for?
Respondent number 3.
3. Number 2?
Number 2, I think they are yet to receive.
Number 2 is whom?
CM of William.
You appearing with William also in other matters?
No, in this matter, but Leslie was. Yes, there's one more matter.
What's this matter, Mr. Simpan?
My lord, earlier matter is WPC 183. It has some connection with this matter, my lord. My lord, as far as this.
So what's your prayer here?
My lord, my
Let
prayer.
us be clear.
My prayer, my lord, is at page number
10.
Page number 10, my lord. Now, we are agreed by the actions of the respondents, my lord.
Why can't we resolve at the level of the CM only?
Yes.
Then
And moreover, my lord.
why do you?
Your Honor, with this matter, the respondent number 3 has already fixed the date for the ritual, and that was conveyed to the CM of William, who has already made a declaration also.
Where's CM William?
CM William are not, and in fact, Your Honor, the petitioner has already filed a complaint regarding this matter against the CM of William in the district council, which is still pending.
We were supposed to take up the matter on Friday, my lord. In fact, but because of the filing of this
The same-
petition.
Now, my lord,
Draw for time being.
now, my lord, may kindly say we are agreed by.
Mr. Sinkan, you can't pursue 2 remedies.
Yes,
No.
Your Lordship.
You can't be, that can't be permitted.
My lord, only
If suppose it is not addressed, then fine.
my only submission is, my lord.
This court's impression that if CM William appears at that level, it can be addressed.
If they can.
Then why
address-
have you come? Where's the complaint?
Page 33, my lord.
If they can address, my lord, that is well and good.
Then yes.
However, my lord, they
We
have
dispose
not-
of for a time being now.
Yes, Your Lordship. They have already filed that complaint is already pending before the district council.
Page number 33, my lord, that complaint was filed.
33 is 1 page only.
No, my lord, there were 2 complaints. First
No,
was-
regarding
27. Page number 27, my lord. This is the complaint, my lord, which was filed. That same complaint was again given when the new chief executive member has joined.
You examine it, Mr. Diglo.
Yes, sir. We will definitely
Yes, sir.
examine it.
When the matter is taken up, it is informed by the Senior Counsel on behalf of the respondent's number.
Respondent's number.
Respondent number 2 is the CM.
Respondent number 1, that the matter is before the Executive Committee's Council. So, with regard to the same pre-amended petition, so, though the respondent number 2 is not appeared, respondent number 3 is represented by Mr. So-and-so, Contempt for represented by Mr. Sundram. As the matter has still not yet been decided by the Executive Committee, which is the proper forum, so this matter stands disposed of with the direction that the app representation before the that will be disposed of within.
My lord, within 1 week's time, my lord, because the date has been fixed on 10th for the
No, they actually, they have fixed another. The petitioner himself has fixed one date, whereas the Dorbar High Court has fixed
See, the
another
thing is
date.
that the main issue. The thing is that you're going into factual matters here.
Yes.
I say let the Executive Committee.
If they decide, my lord, that
They have to decide it first.
yes, let's see, my lord, within a week's time.
Will this be possible or not? I don't know.
We'll
make an endeavor.
Expeditiously as possible, preferably in a week's time, as the functions are fixed for
On
10th.
November.
18 from
That is
the
by them,
same was
my lord.
already fixed on
The
18.
matter stands disposed of.
Or like,
Hearing 64.
my lord, liberty may be given, my lord, to approach in case liberty may be given.
Of course, liberty is there. Any order?
But,
Yes.
My lord, this lordship has heard the weather name on the occasion.
Hmm.
And
In this case, in fact, it was hard at length, your lordships. Hard at length, my lord, and lordship directed me to obtain certain instruction, my lord, regarding 2 attendance sheet.
1 second. I know the division bench is now the chief ones. Come and see.
Where is this auction? This is.
Huh? Hey, 1 second. Oh. After DB2 program. DB2 will join the other guy. Some confusion in the benches, yes. Yes.
but when the matter was taken up in the Mana Workers, lordship has heard the matter at length. And perusing the rejoinder affidavit, my lord, where the next attendance sheets, what the lordship directed the senior.
Yes.
Verify and obtain instruction. Madam, can you see order number 1st August?
1 second, 1 second.
Order. Date of order is 1st August. 20.
First August order?
Yes. 1st August. My lord has passed to order. In course of hearing, the attendance register which has been annexed to the rejoinder of the petition has been perused by this court. The query has been raised as to whether the same is liable to going to be taken into consideration when deciding the matter. Mr. Sansar, to the counsel for the responding university, is therefore to obtain instruction and also verify the attendance sheet from the records. Now, we have annexed this attendance register obtained from the university to show that, my lord, the two groups of employees are here. 1 group, my lord, they go to office Monday to Friday. But those who are engaged in essential services, they go through. There is no holiday. And we have annexed those attendance register in the rejoinder. The question arose.
So next date, Ms. SN submitted that attendance sheet as produced as given rise to disputed facts. Then what happened after that?
Attendance sheets were
One attendance sheet in respect of one writ petitioner that clearly shows substantiate our stand. Saturday, Sunday, never signed. Now, in respect of another writ petitioner for 1 year only, my lord, it seems he has signed on Saturday and Sunday. Now, my lord, I have obtained instruction, my lord. There are a lot of this kind of thing happening in the university, my lord. Though they are not authorized to sign, they are signing. Now, attendance sheet is being now replaced by this machine, my lord, punching machine. Now, we have introduced this. So, my lord, in respect of one writ petitioner, my lord, saying he is claiming for, my lord, 21 writ petitioners. Now, only, my lord, citing one example for 1 year. My lord, that's showing that he signed on Saturday and Sunday, my lord. My lord, my humble submission, my lord, this is purely a disputed question of facts, my lord. If he has any grievance in respect of one writ petitioner signing on Saturday and Sunday, he'll have to go for a suit, my lord, not into writ petition. And this cannot become basis, my lord, generally granting relief for all the writ petitioners. And another point is, my lord, I have submitted one decision delay. This respect of claim of 2011, my lord. Now we are almost, my lord, after 13 years, your lordship.
This matter has come again.
It was listed before court number 3.
This matter was, my lord, partial.
Heard the matter.
There is a lot of confusion happened, my lord. There is a change of roster, all 24 matters. And number of my, so far I am concerned, number of my cases, my lord, almost concluded.
Before this bench?
Yes, my lord, concluded, but it's not mentioned pardon. It's not necessary, my lord. This matter also, lordship will see kindly, my lord. This order, this is the order, no? 1st August.
Who prayed for release? You prayed?
All of them, both of us.
We informed the court.
I was wondering, because 23 is on my roster. Yes. How many petitioners are here? 20?
21 petitioners are there. And out of 21, my lord, 11 of them are engaged in the essential commodities, where they go, my lord, every day, without any holiday. That affidavit is there, paragraph 5. The respondent did not deny that. And one of the attendants I have the next day is those petitions.
I remember this matter now.
Yes. Earlier they were appointed for 90 days, and subsequently from 2011, they started appointing 89 days. And I've cited some authorities, and Lordship said, okay, for the time being, allowed 89 days citation cannot be looked into. Just proceed with the matter.
So we forget the attendance sheet then?
My lord, if you forget about the attendance sheet, the Lordship kindly come to paragraph 6 of my writ petition. Paragraph 6 in my writ petition.
Yes.
Now, the table, my lord, can see the serial number 4, engage security. There is no holiday portal. Number 5 also, security. 7 also, 8 also, 11 also, my lord. 12 also, 13, 14. And
Transport.
number 16, transport department, my lord. There is no holiday portal. And 20 and 21, maintenance. So these are the group of daily wages who go to office every day. And they did not deny. So I have a next one of the.
But the thing is that you're going to get me 1 day extra, correct?
Yes, that is there. That we are not refusing. 5 days, ours is a 5 days plus 1 day. Ours is not 6 days, no. 5 days plus 1 day.
So what do you sign on Saturday, Sunday also? But 1 day you won't get then.
Every day they go.
Fine, but then the scheme is 1 plus 5 plus 1, 1, 1, 6, right?
If it is 6 days, 6 plus 1. If it is 5 days, 5 plus 1. Ours is 5 days.
Well, my lord, I'll show that one.
So your only case issue is 6 plus 1.
It is issued 6 plus 1. That is the policy of the central government. It's just a lordship at
Just refresh because I've forgotten this matter, but I was going through, I just remember that 5 plus 1 is 6 plus 1. That you're given one additional pay.
Yes.
Yes, 1 day.
Yes. My lord, you kindly come to my
daily wage rather. Yes.
They have annexed, my lord, page number 9 of the rejoined day. Annex R1. This is the RTI application put up before the new to ascertain the nature of the service condition of this
page?
Page number 9. This RTI application 1, 2, 3. And now respond to this. University has a given reply. And page number, let's start from page number 12. And 13 May Agreement. This is the 1988 guidelines followed by everyone. Minister, my lord. Recruitment of casual workers and persons on daily wages, review of policy. They come straight to 2. Persons on daily wages should not be recruited for work of regular nature. So they have done here. Page number 13.
Page number 13.
Okay. And point number 2. Recruitment of daily wages may be made only for work which is casual or seasonal or intermittent nature, or for work which is not a full-time nature, for which a regular powers cannot be taken. So I have been engaging for the last more than 20 years. May come to point 4. Where the nature of work entrusted to the casual workers and regular employees is the same. The casual workers may be paid off at the rate of 1/30 of the pay at the minimum of the relevant pay scale plus 10 days allowance for work of job 8 hours.
Now you ask for 6. The casual workers will get 1 paid weekly off.
Yes. My lord, yes. Number 6, my lord, correct point. The casual workers may be given 1 paid weekly off after 6 days of continuous work. Now here, for the time being, lordship, forget about.
Now you say that the payment was restricted to this which they perform with a paid weekly off. So the thing is that you say even we don't take weekly off, we are entitled also to 6 plus 1. But even the scheme of the government says that if you work for 6 days and you're paid one, will that mean you're paid 5 days plus 1 or 6 plus 1?
Now here, if we go by this guidelines, casual workers are normally engaged for 6 days. That's what point says. Casual workers may be given 1 paid weekly off after 6 days of continuous work.
Yes.
So if a person they are engaged for 6 days work and 1 pay off, that means for 7 days they entitled. Now point number 7 also it says. Point number 7. The payment to the casual workers may be restricted only to those days on which they actually perform, that means 7 days, duty under the government with a paid weekly off as mentioned in part 6 above. They will, however, in addition to be paid for a national holiday if it falls on the working days for the casual workers. Now, this is the guidelines of the central government. And I not kindly see the next page 14 for deviation. If any institution wants to deviate, para 11. If a department wants to make any departure from the above guidelines, it should obtain the prior concurrence of the Ministry of Finance and Department of Personnel and Training. All the ministries, departments should undertake a review of the appointment of casual workers in the office under their control on a time-bound basis, so that at the end of the prescribed period, the following targets are achieved. Now, page number 15, last paragraph 4, is very clear. Ministry of Finance is requested to bring the contents of this office memorandum to the notice of all the appointing authorities under their respective administrative control for strict observance. Cases of negligence in the matter of implementing these guidelines would be viewed very seriously and brought to the notice of appropriate authorities for taking wrong and suitable action against the authorities. Now, if I understand properly, it's a strict guidelines. Who cannot debate? If they want to debate, they should obtain a prior permission from the authorities. Now, the
only question is whether you work 6 days or not. That's the only thing.
My lord, there are 2 classes, my lord. 2 classes.
Now again, you come to this order. See next page.
Yes.
The wages restricted only they would actually perform duty. They will, however, in addition, be paid national holidays with 4 working days to 1 paid weekly off, subject to quantity 6 days of work in each week.
Therefore,
Now, this is from the registrar.
from the register, they provided this entirely.
Yes.
And the minutes, my lord, the basis of the impugned order taken by the university, we asked for, and they have given this page number 7. This is one of the order issued by the, not the impugned order, prior to the 1989, page number 7, type copy is 17, my lord. It says, in pursuit of the decision of the 62 EC meeting resolution and such, the Vice Chancellor Nehu is pleased to order revised wages of the casual workers, persons on daily wages employed in the Nehu, as per the instruction of review policy and recruitment casual workers on daily wages, and such. Date, my lord, 1980. That is the first election we had. Now it says the full-time casual workers and persons on daily wages should be paid revised wages at the rate of census, at census, no increments, absolutely lifted from the central government OEM only. All such part-time and workers engaged on contingency basis or to the wages on pro rata basis. Now 3, the wages would be restricted only to the days on which they actually perform duty. They will, however, in addition, be paid national holiday if it falls on working days. They will also be entitled 1 day paid weekly off, subject to the continuous 6 days of working each. So now, if the person appointed in the essential, but they work, in fact, they work not only 6 days.
Come to the next page. Last time I remember, he's saying that regarding the casual laborers engaged in essential services, correct?
Yes. Essential services.
Water pump operators,
security guards, my lord, the cook.
So they are working.
Holiday. Now, this is the order they have issued in by Nehu in 1989. They continued. And only, my lord, page number 18, the original copy is 18A. The basis for passing the impugned order is here mentioned.
Yes. Now, see, you don't understand this. My noting for paging 16, the eligible is based on assumption that the principle of 7-day payment for 6 days work applies in 5-day week also.
Which page?
This one you read. I'm reading this handwritten part, which is typed the last 2 paragraphs or 3 paragraphs of your page 18.
Page 18, yes. This is a type copy of page number 18.
Yes.
And this is the basis of the impugned order being passed. You see, my point noting for page 1 was based on the assumption that the principle of 7-day payment for 6 days work applies in 5 days weeks also. Since it is clear that government update rules do not allow it, the same may not be applied. I really don't know this one. It could contrary to the central government OEM. In view of the above, let the finance clear the deals of March on actual days basis without a 1/6 days additional payment, since this part is against rules. Any adjustment may be done after matter is placed in AC. The review process be expedited.
It's by the VC, it is not.
Now the impugned order, we have challenged the repetition, and the Nehu said is replaced. It is the same matter. Right? Well, if I can refer to the affidavit filed by Nehu. Well, mechanically, page number 8.
No, 1 second.
Nehu.
1 second. Yes. Page
number 8 of the affidavit filed by Nehu.
It's a verification. Oh, by Nehu, sorry.
By Nehu.
Next one.
Next one.
Yes.
15 June 2021. This is in pursuant to resolution number such adopted by the AC in its such 2011. The VC is pleased to order that in the case of casual laborers working a 5-day working day week, an additional payment of wages for 1/6 of the total number of days the casual laborer actually worked in a month be made to them with effect from March 2020. Now, my humble submission is now they reduced from OM says that it should be 6 days normally. Now,
So
they
this one
reduced to
says 5 plus 1.
They reduced to 5 days. Now, even 5 days, they said that 5 days, if I work for 5 days, Monday to Friday, then one will get only 5 days plus
1.
Now, those who work whole week is excluded. That is against OM also. And even it is against OM. OM says 5 days.
Mr. Sen, can the UC examine it again? Because there's some confusion, especially attendance. Also, if we show that you work for 7 days a week, so
Well, there are a lot.
you can't extract
Sir,
labor without
labor, and then you cannot pay, my lord. I understand.
Even if you can't pay, but then if the OM allows 6 plus 1 or 5 plus 1, I think that it should be. You can't, if they're working. Can understand with maintenance, they have small electricians and
yes,
all call it back and call. Then you can't just extract the labor without
Exactly, my lord. That exploitation of labor.
No exploitation labor. Yes.
This is exploitation of labor. It cannot be. But then before that, I'll just satisfy your lordships. Let him complete. I'll just point out.
We understand that. We understand that it's fine. As for noting the VC that says that what that is, we can give.
That is by register, my lord.
Correct. Yes.
No, other thing is this, my lord, these are ministry, all these notification which are issued. Lordship, I think, had dealt with a number of NEHU matters issued by the ministry. These are suo motu has no application in the university.
But you adopted it.
Suo motu has no application in the university.
Correct.
So far we are concerned, my lord, in 2011, we had taken a decision, my lord. What was our decision? 5 days a week plus 1 day, my lord, additional. Now that 11 was never challenged.
That only goes against them. Yes. But the thing is that you can't take a fresh look. Then now this order is very clear.
Lordship.
This order in the case working a 5-day week.
Lordship.
Now they're trying to carve out a case that they're not working in a 5-day week. They'll be covered by this order. They're working a 6-day week. And 6-day week on top of that, they're working 7 days, but they're prepared to say, okay, working 6-day week because they get the benefit of 6 plus 1 day. That means they'll be paid for entire duration of which they work. Whereas for the 5-day casual workers, even plus 1 day they don't work. They're getting paid. They're getting
7
paid
days.
for that.
It comes to 7 days. 6 plus 1. That's what.
6, 5
that
plus
is
1.
That is also, my lord. They have failed to make out a case. The creator. Lordship will kindly take up, my lord, their rejoinder where they have annexed these attendance sheets. Kindly see, my lord. Page 20.
A lot of confusion.
Page 20. Lordship will come to page 20 of 2 writ petitioner only for a particular year only, 2023. My lord.
Yes.
One Mr. Kharpuri, he is one of the writ petitioner, my lord, in the bottom. Now it seems, my lord, he signed on all the writs.
Yes.
Lordship. Now this is with regard to only Kharpuri, one of the writ petitioner. Now, my lord, the order is, Lordship will come. They have enclosed only 2 attendance sheet, 44. Now this is one Kharpuri, my lord. He is also one of the writ petitioner, serial number 8. He has never signed on Saturday, Sunday. This is only what I am saying, my lord, that stands substantiated. 21 writ petitioner, 2 attendance sheets, making casual statements, my lord, we work for 7 days. What do we say? No, it cannot be. 2 attendance sheet, only 2 attendance sheet of 2 writ petitioner, one showing, my lord, somehow he signed on Saturday, Sunday. Other, my lord, clearly substantiate our case, he never signed on Saturday, Sunday. Now, based on these documents, will my lord pass a sweeping order?
We're not passing sweeping orders.
Lordship, my case, my lord,
this court is trying to
I understand.
trying to work out some via media. That if suppose for electricians or like what's the other security guards, who on duty like 24/7. I mean 7 days a week. Now you can't adopt any policy like within your OM only with regard to the 6 plus 1 that they begin to benefit.
Obviously, if there are maintenance workers, my lord, who are round the clock working on, my lord, holidays also, we are under obligation. Now, what we are saying on our affidavit, my lord, no, they are supposed to work for 5 days and they were working for 5 days. Additional 1 day, we are paying. That is our case.
Their case that they're working for 6 days,
my lord,
7 days. They say they're working for 7 days. And so fine, because the 6 plus 1 applies to them, 6 plus 1 they'll get compensated for 7 days. That's the only case. Correct, Mr. Chandrasekhar?
Even that is not based on the document they have annexed. I have now pointed out one document.
They can't rely on the document also. But I'm saying outside the purview of even the whatever, materials that are here. Whether, if they are employees who are rendering, the service. Now, can't you apply that OM in such a way that, they be given the benefit also?
No, that we cannot. We are paying on the basis of actually what they work, man. They work for 5 days
That is
plus
the
one
only
will pay.
dispute here. Court cannot discern sitting here whether they work for 5 days, 4 days or 3 days. We cannot.
Exactly.
And even what Mr. Sen's correct. Now, only in case of one petitioner, he signed on all days.
This attendance is made service.
I just give you which it isn't jest, but it's like an anecdote.
I do that.
Now in one law college only, like sometimes these law students don't attend classes, then they have they with the whoever's in office in charge there, you sign the register later on, or he signs for you, that kind of thing, that you're present and all, they fill up the registry. So what happened once, then this fellow, he was not given his admit card, called to the principal's office. Then, but then he had already already fixed with the office assistant that his attendance should be up to the mark. Then they called the principal. He said that something wrong with your attendance sheet. He said, why, sir? Like, I've attended classes, I think. He said, yes, but even you're present in Saturday and Sunday also. You mark present. Then he charged that fellow. He said, hey, what is this? Why you mark? He said, no, sir, actually I charged me 30 rupees from the students to mark, but you give me 50 rupees, I fill up all the days. so as present, so this is not a case like that.
And the other thing, he's saying this is happening.
True story.
And this is, my lord, my learned friend is saying this is happening from 2011, 23. After 12 years, my lord, it is believable, my lord. A person, he rendered his service not getting for 12 years. He sat over it, and 23 he comes, my lord, and filed a writ petition, my lord. My humble submission, my lord, even if some of them have signed, my lord, we are saying nobody has signed. They are not supposed to sign.
Whenever we ask for instructions, we cannot rely on this.
Lordship.
It's disputed facts, so we can't
file a
gospel
suit,
truth.
I don't may submit.
Like again, the anecdote I'm saying, signing on all this.
But the attendance sheet is furnished by the neighborhoods. And they prepare
Fine. No, we're not looking at that. We're just looking at the basic grievance. Number 2011, the order came out, never challenged it. Now you're coming, this petition file 23. After 12 years, you file saying that we work 6 plus 6 days, so 6-7 days, you're 6 plus 1. And the OM doesn't allow, they allow 5-day a week only with 1 additional day. So that's the only thing.
My humble submission is that OM, which they have adopted from 1988, if they want to defer it in 2011, they should obtain the prior.
They have not done that.
Therefore, the action taken by the
is that OM still holds good?
My lord, so far adaptation, these are to be formally, my lord.
No. Has it or does it hold good? Is the OM been adopted? I mean, the principles or the guidelines in OM have been applied by NEHU.
This how to be.
The only concern of the court is that they should
should not be explored.
Like it's the court of equity.
Lordship will see even 13, even these guidelines, my lord, we have adopted because this has to be extended by the UGC, not by the ministry. Ministry is nobody, my lord. It is the UGC, they extend, my lord. Now, even the guidelines, my lord, the last guidelines on page 13, my lord, clearly say payment of casual worker may be restricted. My lord, the rejoinder, page 13. The last clause in this page, my lord.
The point issue is very small, but only the relief,
Yes, my lord.
Yes.
Payment to casual workers may be restricted only to the days on which they actually perform duty under the government with a paid weekly off day.
That is what
so that is clearly provided. It's not that.
That's why this court is saying that if it is possible for the NEHU to see which are the employees who are working, how many days a week they're working. That's the only thing. You have to undertake a new exercise.
No, my lord, because when we prepared the affidavit, I obtained a specific instruction. They examined all those things. They were working for 5 days plus additional 1 day.
That you've submitted earlier on. Now I remember you said that yes, they work only 5 days. They're not entitled to the 6 plus 1. They get 5 plus 1. That's all.
So that is
but Mr. Chandra says no. We work 7 days a week, so at least give us 6 plus 1. That's all.
Even his own document attendance is showing otherwise. Showing other ways.
There are two categories of repetition here. One group, they go to office for 5 days, so they will entitle 5 days plus.
So we'll segregate the things.
Second
so you have to segregate. That's why this court is saying, let them see from the petitioners who's doing essential services, who's not.
What is there? What is this prayer, my lord? He is saying now 2 class of employee. Now this is a common read petition.
Doesn't
Same
matter.
prayer.
These people, you see, they are small people. You can't expect them, to come with that's the only thing.
But
Otherwise, Mr. Chandraso, delay, then no clarity, there's not enough material to show that the case can be thrown out. But we just, out of compassion, we say, okay, fine, let them examine whether it is a fact that you have rendered duty 7 days, we'll entitle 6+1. That's all. And that'll examine. Then if they need it, they have to ask for what they call exemption from. But I don't think you need. UGC has adopted this.
Yeah.
Yes. Then
they are following the that way.
So by humble submission is this?
Delay approach. They may not entitle the past benefits for them. They have ways.
May not. Forget about past benefit. That's out of the question.
The deduction continue. That's the problem.
Lordship can, my lord, only thing Lordship can. If somebody, some of them, they are admitting their attendance sheet here. They are saying we have never signed, my lord, on this page. Now, if one read petitioner is...
see, we're not relying on the attendance sheet, my lord. The anecdote I've given, we can't rely on the one given by the petitioner. Unless the original,
If the
record from the university,
we can't take
that will be my voluminous records like that. Instead of this thing, my lord, my learned senior friend, what he can do, my lord, he can file a suit, my lord. All these records, other things we are under obligation.
You can file a suit because the nature of your claim will be on disputed facts, number one, and number two is that you can change to a private dispute for since a casual worker also.
From the submission, there is no disputed question of facts. And the notification which we have challenged is the contrary to that OEM. And you admit that they are open, they are complying with that order. They are following that OEM.
Now, yes, okay. Some persons died also.
But therefore, we have impleted. It made a substitution. So we paid for some recovery. But they are in a pathetic condition, my lord. Yes, petitioners.
That is why, see, Mr. Chandraso, in ordinary circumstances, this court have disposed of this matter by now. Only thing is that considering they are all casual workers depending on this. What to do, Mr. Sen? Are you willing to examine it?
These are the problems, my lord. What are the problems I have placed it before, my lord? I leave it to my lord. And there are 21 read petitioners.
In para 6, they did not deny those who are involved engaged in the essential security services. 11 of them are out of 20. 10 of them are another sets who go to office Monday to Friday, 5 days.
Then para 6, the affidavit.
In my read petition itself. You did not deny.
Is it affidavit?
Clear out. Para 6.
Of the affidavit of your petition.
Affidavit responded that affidavit, my lord. Who has responded? Para 5 of the Neho affidavit, they did not answer. Then the 11 of them are not engaged in the essential services or security.
How can we say that the petitioners are here being agreed with order past 2011? We have to record that.
They agree with that 2011.
They're not under challenge.
You have challenge order 2011.
We challenge and Nepal subsequently they say that they have replaced. But it is more or less the same. Lordship is sitting in the rich jurisdiction. Lordship can mold the relief or so.
How can we first asking you to segregate the petitioners? Now you ask me to mold the relief. Then what? then what you ask for and what relief comes will be totally,
Lordship can see the impugned order which challenge the petition. That is.
You have come separate petitions makes it easier. Yes. Clubbing also, if the cause of actions are different.
But 71, page 71 in the writ petition is the order we have challenged.
So it's simple. See, with reference to a letter number so dated 31/3/2011 is that first letter.
But
The order? Orders when? The first order, Mr.
Nehu Annex. Nehu one is
Oh, the one regarding that 2011 where he didn't challenge. Where's that?
That is Nehu affidavit, page number 8.
Yes.
Page 8. 15 June 2021. And the one I challenged is 20 April 2021.
31/3, where's that? 31/3, where is it?
1.3. Well, 31/3 is not here.
Where's it, Mr. Sent in the affidavit?
Which one? 31 yeah?
See, this reference to an order of the 2003 dated 31/3. Where's that? Impino page 71 refers to, with reference to a letter number so also dated on the above subject 31/3. What letter is this? I thought this is letters ordered, but this letter is 15 June 2011.
Yes.
Not 31/3. You don't have it, Mr. Chandra?
They don't have. They don't have.
Yep, 31.
Hmm?
They don't.
Hmm. What to do, Mrs. Sen? You can get it?
You can get it.
Yes, sir. In the under course of hearing, it is
Just
noted
remember
that
31 just
letter dated 24/2011. Reference has been made to a certain letter.
Take the screenshot.
31/2011,
What is this? Bring that.
which is not before this court.
Next is ours.
Mr. SN, please will have some time to produce this.
What about that case?
Yes,
Mention
after
already.
2 weeks. See, you will try to mold the relief, but only if it be for the consideration. That's all. Because if we are this court, in the mind of the court is this, that if you're working for the actual days, there has to be concrete, materials or evidence to show that you're working in these days. These are the class of employees in security guard have been working, like Mr. Petitioner, he has been working like that. There has to be concrete, the nature of duties, how many days they work. Then if you're going to pay an actual days that they work, then they can do a certain kind of a survey again, and then if you're entitled, you'll get it. And on the basis of the petition.
Actually,
The petition is does not cover anything, Mr. Chareso.
But in the meantime, if my senior can produce a
I'll
petition
produce.
also,
Huh?
along with that letter, it will reveal everything.
What
They are the
one?
one who made it.
We're not going to go to the.
This is a voluminous starting from 11, my lord, to. That's why I said, my lord, the specific documents, if he is really keen, my lord, he can file a suit. We are under, my lord, we will produce there, they will have to examine, my lord.
Yes.
Right. Original.
Otherwise, we'll resume. Yeah.
Again, we'll have to come.
Item number 1.
1 second, let the file come. Yes. Just for you, one. तो this bar खाली है. Welcome report. Yes. Okay. So. Yes.
Pursuant to order of the Lordship of 9th September 2025, that is against 22nd interim report, Lord. And if your Lordship will see, we have given the detailed status report, and the status report was filed on 27th October 2025, Lord.
Yes.
We have the status report dated 27th October 2025. Lordship has the status report, Madam.
Yes.
Lordship, there are various recommendations by Justice Kadaki. And those recommendations have been dealt point-wise, my lord. First point, if your Lordship will kindly notice at page 1.
Yes.
First direction is suggestions as to more efficacious and reliable method to ensure auction of coal is still lying in CIL designated depot. In pursuance of the direction of this Honorable Court, in addition to suggestions made previously in report dated 22nd August 2025, such as stipulation for deposit of full coal value by successful bidder, failing which penalty and forfeiture of EMD, and part payment and stipulation for time-bound lifting of coal, failing which demurrage charges to be imposed, expedited process of confirmation of sale, and issuance of mineral transport challan. Meeting have been held by bidders, coal-based industries, and further updates as directed by the committee as summarized as under. Regrading of coal in depot. During the meeting held on 22nd September 2025, the state government approved committee that prior to auction of the reassessed, re-verified coal by Coal India Limited, grading of coal lot has already been done by the coal owners as mandated in auction procedure, and certificate of grading is available in respect of all lots available in the designated CIL depot, and the same has been notified in the auction notice issued by Coal India Limited.
Now, 1 second before we proceed, has the auction totally stopped now? Mr.
No, my lord, the auction is going on, my lord, and Coal India CIL will be in better position too, because
We just want to know, now the dry season is coming, whether it's stopped now the auction? From the depot.
We have not held any auction after 14/5.
After 14th May?
17/4.
17/4. And whatever coals lying there, still lying there. Okay, yes, please continue.
Yes, my lord. So then coal, if your lordship will see that in second part, what has fallen from your lordship is in page 3, small Roman 3, my lord.
Yeah.
Page 3 of
Yes.
inventory coal owners, Coal India auction process conducted, reducing the price of coal or for bulk consumers in the auction process conducted by Coal India Limited. Divisional Mining Officer Jovai and Office of Director of Mineral Resources informed, as per discussion with coal owners bidders, they have expressed their unwillingness to reduce the price of coal during the auction process as proposed by Mining and Geology Department, and requested the authority to stick to earlier order issued in this regard, mandate of 2,160 per metric ton towards cost of transportation, loading charges, handling, and
Please explain this part to us.
Yes, my lord. The issue is, my lord, that the price of the coal has been determined. That minimum price will be 2,160
Right.
per metric ton. Out of that amount, my lord, 10% amount goes to the Coal India MMTC, which conducts the auction, my lord.
Right.
So therefore, now the because of the market not lifting the coal because of the prices have come down and supply to Bangladesh also is not taking place. So there is no bidder as such for lifting of the coals. So there was a proposal to reduce the price of the coal, which was not accepted by the original owners of the coal, whose coal are forfeited and kept in the coal depot, my lord. That is the factual position.
No, but then suppose this bulk suppliers have they put up any price that they're willing to buy at?
No, my lord. Bulk suppliers also, if you lordship.
Bulk consumers rather.
Bulk consumers, my lord. Sorry, my lord. Bulk consumer, my lord. There was some issue because of the quality of the coal, because bulk consumers were not also ready and willing to take the consumer. Because if I have to supply them, my lord, I have to supply on a rate.
Certain calorific value, yes.
Transparent and fair value, and for that the owner of the coal, those the miners who have mined the coal and their coal have been deposited in coal depot, they are not agreeing for reduction in the price, because we propose reduction of price of coal so that it becomes more lucrative to the bulk purchasers. But there is a stalemate on that point, my lord. But we will try to resolve that issue.
So then this cannot be resolved if if they're not agreeable to a lesser price, number one, and number two, there are no bulk purchases. Then where does that leave us? Where does it leave the
solution is, my lord? Solution is that.
What is the solution?
Yes, solution is that CIL should come out with the auction process again, my lord, because it has taken place only in the April, my lord. Now we are.
No, that besides the point. Then how do we get rid of all this coal? How much is still stuck now in the depots?
That data is, unfortunately, I was also looking for that data. That data is not part of the report because we have responded to the observations.
Because we are being stuck in the in the what do you call it, stuck in this little what do you call it, the fine print. The bigger picture is that the bigger picture we have to get rid of this coal.
What I can do, my lord, is that your lordship kindly give me opportunity. I will place the exact data of the coal which are lying in the coal depot, and when was the last auction held, and what is.
And number two is that now what about the illegal coal has been seized? That is being auctioned very fast.
Because those
and that is seized by district authorities. That is auctioned under their orders.
Those auctions are taking place pursuant to the order passed by the Chief Judicial Magistrate of respective.
Of course.
And there the money goes to the state because those.
Right. I'm saying those auctions are going on.
Yes, ma'am. Those auctions are going on. Without that data, also I don't have.
And only thing is that that auction is going on, but only thing now we are stuck with this huge amount of coal in this CIL depots.
Yes, my lord, and we have to maintain those depot also. There is a cost of maintenance of those depot also.
So we don't have any quantitative data with regard to how much coal been auctioned through the seized coal and and this inventorized and what's it called, stock coal in CIL depot. So we don't have quantitative data of how much exactly is the inventoried coal now totally. And number two is how much coal been sold through this auction through the respective jurisdictions of these courts.
No, we do have the data, my lord. We will place that data on the next date of hearing.
Because the thing is that now before the committee also, then if this is not going to work, then what other avenues are there which can be explored?
Lord, we'll try to explore that avenue also, because ultimately we have to dispose of.
Well, if we have to start a clean slate, Mr. Archival General, then we have to get rid of all this coal. Whatever is lying in these depots, it has to be all gone, all sold, clean slate. So whatever coal that is mined or is present will be illegal, unless it's under a license or under a mining license. Correct? So the state is going to start on a new slate. If we still have this inventory coal lying around, there'll still be illegal mining, there'll still be piling, it's a never-ending process for another 20 years. Our coal has been banned now, we are on the 11th year of the ban on coal mining. Yes, please continue then.
Yes, my lord. So what I was praying, my lord, that these two data.
Okay, that two data we will pass orders, but please continue with your status report.
Yes, my lord. These two data is important, my lord. Now, various recommendations, coming back to the recommendations part, my lord.
Yes.
If you also will see page 3. So,
Yes.
we have some we were on the point A, my lord. Efficacious method to ensure auction of coal still lying in CIL depot. Now, one of the proposal which was recommended and suggested, my lord, if you also will see the page 2, small Roman 1.
Yes.
Because there was an issue of regrading of the coal. The coal's quality, there was suggestion from the committee, but that suggestion, my lord, if you also will see, committee requested the state government to conduct regrading of coal from grade 1 to grade 7, because that is a cost, it has got cost implication, my lord. And it has already been done by these coal owners under the mandate of CIL, my lord. Grading of coal has already been done by the coal owner as mandated in auction procedure, my lord. So there will be no purpose will be served, my lord. Then Roman 2, my lord, divisional mining officer had submitted a report on regrading of 5 coal owners whose coal is in category grade 1 to grade 7, as submitted in earlier report prior to auction of coal. As per aforesaid report, it is observed that gross calorific value of coal is more or less the same as submitted earlier by coal owners and falls under the same category of grade of coal as indicated in earlier reports. Such exercise was completed within timeline. So sample survey was conducted. On the basis of sample survey, the grade of the coal was found to be same, my lord. So no purpose will be served, my lord. Then, my lord, third, in pursuance to direction issued by committee during meeting held on 22nd September regarding meeting with representative of inventoried coal owner to explore the possibility of reducing the price of coal was bulk consumer in the auction process conducted by Coal India, divisional mining officer, director of mineral had informed as per discussion with the coal owners, they have expressed unwillingness, my lord, to come the price, my lord. That issue need to be resolved. We'll try to find out solution to, my lord. Now, point B, my lord, submission of proposal before oversight. State government has already submitted proposal before oversight committee as directed by Honorable Kataki committee and a tabular chart of the proposal and their present status. Now, my lord, there is an amendment of the revised. Detail of the proposal is mining department had requested oversight committee for approval of further amendment to revised comprehensive plan 2022 as suggested by Coal India and approved by committee for debarment of defaulter to participate in the auction, because those who do not lift the coal, they will be blacklisted, they will be debarred, my lord. The matter is pending with the oversight committee, and lordship's some nudging will help us in getting that clearance, my lord. 2, my lord, paragraph 2, proposal regarding survey and other work for mine closure and reclamation of abundant coal mine areas in district amounting to 4 crore 2 lakh so and so. In compliance with the directive issued by Oversight Committee, Regional Office MOEF and CC Shillong has convened a meeting on 16 July with the stakeholder to discuss the issue pertaining to proposal. After thorough review, it was resolved to return the proposal submitted by CMPTIL to technical committee for approval. Before the technical committee MEPRF shall evaluate the proposal expressly and obtain approval from the oversight committee. This issue is also pending. Restoration and reclamation
No,
of
it's not in the same
mining
place, okay.
land.
Yes.
And this is the third proposal, my lord, which is pending with the oversight committee. C and E, my lord, issuance of notification incorporating the amendment relating to timeline for payment for bid evaluation, which we will take a step, my lord, and we will do it in period shortest possible period. The amendment is on our end, my lord. D and F, my lord, intimating successful bidders who have not deposited their bid value or not lifted the call to comply with requirement of face value as per CROT revised complaint. Director Shillong, dated 7th October, has written to all successful bidders who have been instructed to deposit the bid value or lift the call within 1 month, failing which necessary action of forfeiture will be indicated and re-auction of the call be initiated as per 8J of revised, my lord. 1 month time has been given with effect from 7th October, my lord. 1 month is over on is going to be over in next 2 days, my lord, next 3 days. So we will, after that we will take action, my lord. Now, meeting with the legally established co-owned plan to ensure their participation in the auction. Director of Mineral Resources has convened the meeting of all co-owned plants, all district on 21st August. During the meeting of concerned co-owned plants were advised to participate in the coal auction process. It is available locally and it is reasonable price. They were also advised, my lord. It was also informed to them there are plenty of seized coal with 3 to 4 districts and an auction process. So we have we have asked to them to. Now, my lord, point H, demolition of illegal coal plant, my lord.
Any demolition done?
We have no, my lord. There was, in fact, there is a Supreme Court order also where the Supreme Court has passed the order that those which can be regularized, we have to regularize, and those which cannot be regularized, my lord, we have to demolish it. So we have asked for some fund for that purpose, my lord. At least at that stage, my lord. Point F, furnishing or information pertaining to functional coke oven plants before the committee. That is being also submitted, my lord. Joint inspection of coke oven plants. This is by monitoring is being done by Meghalaya State Pollution Control, and the report of Meghalaya State Pollution Control Board is, my lord, all consented and non-consented plants ensure that no coke oven plants are operation being established without consent to board. Board, along with other departments, conducted surprise inspection in West Qasim and have stated in their report that all 9 consent plants are not in operation, my lord. Inspection was carried out, and this is the inspection by Meghalaya State Pollution Control Board, and detailed report is also placed, my lord. So far as source of the page, point K at page 12, my lord, at the bottom. Completion of audit of source of coal of captive plants or cement companies and coke oven plants and ferroalloy. During the meeting, so 20 so-called notices have been issued, my lord. Some have responded and some are in the process of responding, my lord. That is being issued, my lord, and number of the coke oven plants. Sorry, number of these are mentioned in paragraph page 14.
One second.
My lord, so-called notices at page 14, if your lordship will kindly notice page 14, small Roman 4. Issued for illegal procurement of coal to these plants, my lord, from M, my lord, and we are examining it, my lord, and summary of action, if your lordship will see at the foot of the page, page 15, bottom. Total so-called notices issued to 20, illegal procurement notices 13, NOC from outside state purchase. All units were directed to furnish replies. My lord, this is being examined, my lord. Final report is not out, my lord, and we will place that final report also before the committee, my lord. And then, my lord, the assessment of L&M action plan is being prepared, my lord. That is also in the pipeline, my lord. Tentative roadmap is they have submitted on 8th October, my lord, which is examined.
Yes.
So, all these measures, my lord, and page 20 is also regarding the inquiry in respect of illegally mined coal of 3,960 metric ton, my lord, page 20, point N.
Yes.
So we have found the coal and we have taken action, my lord, as per MMDR Act, and report of Deputy Commissioner is also placed on record. And so far as aerial survey is also being conducted, my lord. So these are the brief outlines of the various actions taken, including pollution reduction plan, my lord.
So basically, what happened is that we have taken 2 steps forward, 1 step back now.
No, what has happened, my lord?
The auctions are happening, reports are not in place, comprehensive plans to be amended, notifications have to be issued, the coke plants have to be demolished, the audit is not complete. I mean, where are we standing? And we have reports that in some village, some Lom Bangla, something, there's under the nose of the SP and whatever officials that there, mining is going on.
No, my lord.
I think we have to, negotiate the entire issue. I mean, we have to call for some personal appearances. We have got a report also. We saw it in the, actually we're not supposed to look at media reports, but that was very compelling. Because on the complaints of the villagers, and it's there reflected, I think, they had seized coal there in May 23 also. In May 23, 3,000 metric tons was seized from this place called Kremlang Shat under Lumbangla village, East Janta Hills.
Yes.
And complaints there again was made September 27. May 23, 3,000 metric tons were seized. But in October, mining has resumed.
No, my lord, that, my lord, we will check and verify, but wherever we find illegal coal, we seize it.
But then if I illegal coal when complaint was made, and in spite of that, it just went on blatantly.
No, my lord, we will check it, my lord, because there was one complaint. If your lordship, there was
Complaint is not on record. It's not on record. I'm speaking off the record. This is just from general information that's been procured.
My lord, we will certainly look into the complaint, and if there is something.
Oh no, I mean that is otherwise. Who is the superintendent of police of this East Janta Hills? He has to be removed if he can't do his job.
No, my lord, we'll check it, my lord. We'll find out, particularly if there is any such complaint or report, because it has not come from Justice Kataki's knowledge.
No, that come from Justice Kataki's knowledge. This has come from other sources.
Yes, my lord.
Public domain rather, not sources.
Yes, my lord. If we get the material or any source, my lord, we will come back and we'll give.
We'll record and order like it's come to public domain. You know that. Yes.
I'll check it, because I'll find out also, my lord. I'll check it and we'll take action accordingly, my lord. Because I'm not denying, my lord, there will be some cases where illegal mining may have taken place, my lord. But by and large, situation is under control, my lord. I mean, it's not that I'm justifying, my lord, that wherever there is.
No question of justifying, the question you have to assess. You know, it's a question of, you also have to work in, not working at cost purposes.
Yes, my lord. So, my lord, if wherever there is even complaint in the media report, etc., those complaints have to be looked into, investigated, and reported.
I think, if I'm not mistaken, if I may say it, I think there's some political person who had gone there. It's come out all over. It was all over the press. So we were very alarmed that how can this go under the radar of the.
Because I did in Shillong Times, so I check every day, my lord, whenever I posted, but in other newspaper I have not. So we will take note of that fact also, my lord, and we will immediately come back to your lordship exactly what has happened, my lord. Those fact finding report will be required to look into this issue, my lord. Because as of now, my lord, those are the procedural matters are going on, auction of the coal, and inventorized, non-inventorized, wherever illegal mining. So the state machinery is active and it is taking action. And with the power department, the electricity, the industries, cement industries or coke industries, wherever we question of illegal procurement of coal is there, my lord, we are also issuing so-cause notice and asking for data from each of the coke oven plant, my lord. So therefore the actions are being taken, and time to time Justice Kataki is also monitoring us very closely, my lord. So even in the areas which were not initially assigned by the Honorable Supreme Court, and we are cooperating, my lord. We are not complaining, we are cooperating. That the law is being 2-3 data will be required.
Mr. Ahmed, anything to add?
Our function is limited to auctioning. Whenever we are directed, we auction.
No, of course, but I think the auction has stopped since April, 17th of April.
Yes. And as
But
per
there is
the
no order stopping coal.
There was something that happened. I think why he had suspended the auction. He has any order from the government?
No, my lord.
nothing.
Then the auction process should recommence. There might not be demand. The market doesn't mean that there will be a total zero demand.
This is from the comment.
Yes, take down.
I would suggest at least there should be a reissue of notices for second tender now.
They should take steps, whatever step necessary. Yes,
We were to elect 10,000 tons of coal lying in the depots.
10,000 tons?
No,
Much more, I think.
You like 10,000.
2,10,000. 2,10,000, right? 2,10,000. So, yes. A status report on behalf of the respondent state has been filed to the 32nd interim report of Justice B.P. Katuki retired committee. So, the learned Advocate General has fairly submitted, and on the basis of this report, that there has been no headway or any substantial development to a more efficacious or to ensure development in the auction of the coal still lying in the CL designated depots. Correct? The report has indicated that even the possibility of the coal being sold to bulk consumers at a reduced rate has not borne any fruit. So apart from this, apart from the should stop, it is also submitted by Mr. MZ Ahmed, learned senior advocate with so and so, on behalf of Respondent Coal Limited, that the auction of coal lying in the designated CIL depots has come to a halt since 17/4/2025, though there are no orders suspending the same. Stop. Yes, the amount of coal, it is stated to be in the region of 2,10,000, which is still lying unauctioned. So, it is also reported that the issuance of amendment notifications relating to the time limit for payment of bid value and lifting of the purchase coal, as well as consequence of non-compliance thereof, as approved by the Oversight Committee, is yet to be notified. Why has not been notified till now? This, I think, this is the third time this matter has come up regarding the same thing, notification of the consequences of non-lifting of the purchase coal.
Because, my lord, what has happened that NGT has constituted this committee, oversight committee, my lord. So direction was to...
No, it's already been approved by the Oversight Committee in this regard.
No, my lord, if your lordship will see, that is pending in the chart, if the chart which I have just before your lordship. If your lordship will, last column at page...
No, debarment defaulter, yes. But the thing is that point B, you're touching the submission of proposal of Oversight Committee. We're not on that. We're on point C and E.
Sorry, C and E. We will do it, my lord. Yes, there is a default on our part. Yes, C and E in default. We will do it in your lordship issue direction within 10 days. We will do it. Within 10 days, we have to do it.
Yes. Lifting of purchased goods. Um, this court notes its displeasure and expects that the notification be issued at the earliest, as also intimation to successful bidders who have not deposited the bid value and or lifted the coal to comply with the requirements or to face action as per the revised comprehensive plan of 2022. The status report also shows that there has been no demolition as yet of illegal coke oven plants. Reason given that the request for approved sanction of the expenditure for demolition and dismantling has not been arrived at, nor an updated report furnished to the committee. Stop. The report has, however, indicated that the Meghalaya State Pollution Control Board is monitoring all the consented and non-consented coke plants, and that in the report, in a inspection conducted in West Khasi Hills, all 9 non-consented coke plants with 17 number of chimneys not in operation, in East Jayanta Hills, that no coke plants are in operation, and in West Jayanta Hills, these are consented coke plants.
So far as West Jayanta Hill, there are 2 Milord, special coke.
Special coke and Rihasi coke.
Yes,
What as how much? Is in operation. No coke plants in operation. Yes, it has been stated that 2 coke plants, that is MS Special Coke, is ready to operate, and Rihasi Coke is not in operation. Therefore, as per the report, it would reflect that no non-consented coke plants are in operation. It is further mentioned in the report that the legally established coke plants have been informed to participate in the auction of seized coal, which is available in 3 or 4 districts, which will be auctioned by respective district administration. With regard to audit, still uncompleted.
Yes, Lord. Audit is still going on, and that you also will find at the summary of the report. You also will find at the foot of the page at page 15.
With regard to next paragraph, regard to the completion of audit on the source of coal of captive power plants of cement companies, coke oven plants, and ferro alloy plants. Even though this requirement has been flagged, been flagged on many earlier occasions. It appears that the same is yet to be concluded, and as per the report, 20 show cause notices have been issued, 13 for illegal procurement, and 7 for NOC for non-requiring NOC for outside sale purchase. So it's therefore expected that the audit is to be completed, so fast track and completed as expeditiously as possible. In respect of preparation action plan for segregation of areas having illegally mined coal dumps on the basis of terrain, accessibility, etc. The report states that a tentative plan for carrying out physical volumetric assessment of coal stocks stroke dumps has been submitted coal dumps physical volumetric in respect of the report submitted by MS Garuda UAV has been put into place, has been submitted in East Janta Hills. And with regard to South Garo Hills, no further action. Let's go see. It's East Jant Hills 15. 1 second. It is also further. This is the last. There was a last. I think where's that regarding submission of fortnightly reports. Where is that in your last status report?
That was below.
No, that is in the 1 second. 22nd August.
22nd August.
Yes. Yes. We've mired in papers now so much.
22nd August is the.
Yeah. Now, where's the recommendation where you that there will be a fortnightly report prepared by Deputy Commissioner?
Your Lordship will find page 12 of 22nd August 2025 report. Because no, and that Your Lordship will correlate, my lord, with the present status report, my lord.
No, yes, but where is that where you propose that fortnightly report?
No, it was. I'm sorry, my lord, that may not be there because what I see previous report and current report, my lord, I'll check again, subject to correction, my lord. If my memory serves right, my lord, it has to be done and timely report has to be filed.
No, the thing is that, see, what happened was Garuda had done the drone survey, there are 151,000 some dumps East Jaintia, South Garo Hills, okay, dumps, then Southwest Khasi Hills. So as per the drone survey, now, it said that these have escaped, they're not in CIL, and so there's have to be physical verification, correct? And then reports that you asking for reports from.
From page 18, my lord, if your lordship is pointing out page 18 of the latest status report, my lord.
Not to the committee. Yes.
You know, my lord, Garuda has found 1,572 dumps, out of which verification.
That is fine. That is fine.
303 coordinates, my lord. 303 coordinates has been verified, my lord.
Thomni.
And in those coordinates,
Right. Okay.
Garuda has
Thomni, with regard to the connected to the early one, with regard to the assessment. This is one for the report in preaching near the Purnam. Absolutely confusing.
What has happened, my lord, if your lordship will see the report, Garuda has found 46,900.
No, fine. But the thing is that the steps that you're taking, you see, the steps that you all have to take with regard to physically verifying whether this code exists or not, whether it's still there, because
yes.
Yes.
Yes, my lord, but after verification in 303 dumps, my lord, we have found that for physical it's 30,000 accepted and proven, and we have found 27,000, my lord. 27,033.
1 second. You think, Kohli, because we don't want your two reports to go, they're going, what do you call it, cross purposes.
What we can do, I can prepare a chart, my lord, on this issue, that that the status report on each in survey of these dumps, my lord.
Regarding the assessment. Always cuts you. You see, your proposal is very convoluted. The thing is that what you should do is that there should be a definite, what do you call it, regarding this process, some definite steps we take in. Because you have said that, okay, fine, Southwest Garo Hills, the physical verification has been done, this much of coal been found. The thing is that there should be, like the recommendations of the 33rd report says, should be immediate steps to reach out all these coal dumps as locations as found with aerial survey.
Yes, my lord.
Yes.
What we have done is that we are, if your lordship will, know, you have the.
Anyway, we won't record anyway because recommendations are there in the 30th report. And yes. Yes, Namtan. For carrying out with God in each gentile stop. Those stated in the report that a fortnightly report on the progress is to be prepared for the remaining districts, that is South Garo Hills, West Khasi Hills, East Jante Hills. It is expected that the state respondents put in place a definite plan with a definite what do you call it, within a definite time frame, or timeline for the said inquiry to be completed. So, the report also states regarding the completion of inquiry in respect of the coal found in southwest Khasi Hills, as also the steps taken to identify the names and respective coordinates on the claims of certain applicants about availability of coal stock. So, overall, this court notes that, as observed earlier, there has been no substantial progress, and unless effective steps are taken immediately with regard to restarting the auction process actively, the disposal of the more than 210,000 of coal seems to have hit what do you call it?
Roadblock.
Not roadblock, but seems to have hit what do you call it? Stalemate. Yes, seems to arrive at a stalemate. Stop unless the set plan is put in place. The problem that's persisting, the problem that is present will persist, leading to more illegal mining in the guise of inventory and recalibration. Stop. Next paragraph. The 33rd report, interim report, also been placed, which has been noted in the earlier order, and this court again reiterates the status, reiterates the necessity of notifications to incorporate amendments of the revised comprehensive plan, which have been approved. Also, the amendments and the plans which are approved and its amendments, and to ensure a more effective inspection by the Meghalaya State Pollution Control Board to ensure that no illegal coke plant is established. So the 33rd report also flagged that recommends immediate commencement of the process of reaching out to all the coal dumps locations found by the drone survey, since according to deputy commissioners themselves, such process could be initiated from the month of October and complete the same by 31st December in respect of each Jaintia district, and by 30th November in Southwest Khasi district and West Khasi district, and also to take appropriate action under the MMDR Act, including the shifting of such illegally mined coal to centralized place in respective districts. Stop. The 30th report is also very alarming. And you reply to this. There's some observations here. Especially at point 7 of the report, which is with regarding the change in the specific gravity of coal in calculating the volumetric assessment of coal made by Messrs. Garuda UAV. inasmuch as it is stated that it appears that attempts being made to reduce the quantity of illegally mined coal in such aerial survey conducted, which may allow for continued illegal mining activities. So, with regard to other recommendations of the report, it is expected that the state respondents will come up with concrete information and concrete up-to-date information as to the steps that have been since been taken. So, without further elaborating, it is re-emphasized that there should be an immediate initiation for the process of auction of reassessed, re-verified, inventoried coal presently lying CL designated depots in compliance with the revised Comprehensive Plan 2022 after amendment as per the approval granted by the Oversight Committee, and also in strict compliance with the requirements of clauses 8 bracket J and 10 bracket small p of the said revised Comprehensive Plan 2022, pending finalization of the process to find out a more efficacious reliable method of disposal of the coal. So, before parting with the records for the day, this court notes that in the public domain, there has been reported that in October of this year, there has been blatant illegal mining being carried out at a location known as Krem Langshat, Lingshiet, under Lom Bangla village, East Jaintia Hills. This court has taken note of this report, is that as note of this matter, inasmuch as per the report complained in May 2023 itself, 3,000 metric tons of illegally mined coal has been seized, and September 27 complaints have also been lodged with regard to illegal mining activities, which the authorities, it appears, did not take any steps or action on the same. So, the copy of the 33rd interim report is to be furnished to all the parties, and they respond to file status report before the next date. It is a matter it's a matter 1st week December, maybe 4 weeks, and so on. So, see, Mr. Abidjan, it's really disturbing because it seems like there's a.
Yes, my lord, that is because this was not into my knowledge also, my lord, that the incident.
We're compelled to take it, to take note of that.
Yes,
Item number 2.
that is there.
Yes. Okay.
Should I bring for some? Lordship, I'm praying for certain documents, Lordship, we have applied for copies. We are yet to obtain it, Lordship, because it is a very.
What documents?
Certain pleadings, Lordship, it has inevitably lost.
What pleadings?
Lordship, 2 rejoinders, Lordship. I can.
Who rejoined us?
The one filed by us, one filed by them.
You want to join? You don't have copy with you.
Some different. So I'm just praying for a week.
My lordship, they have already wasted 3 dates, my lordship. Every time they take date, and already they have compiled their report. If you may go on the rejoinder filed by them, my lordship, on 26/5/2025. It is the entire pleadings, the entire PI has been. Yes, my lord.
Ready
They have
today?
consolidated. They have already consolidated it.
You ready today with the matter?
Lordship, I need to make the convenient compilation.
Then we'll have we'll dealing this matter from the other file. We'll have it after 1 week.
Yes, my lord.
Yes, yes, Mr. S. Deb today again has renewed a prayer for preparing the compilation, which is objected to by the respondent number 14, appearing in person. Stop. Concern who submits that all the materials necessary for adjudication already present for the court. Stop. In the view of the matter, this PIL number 8/2022 shall stand delinked from the PIL number.
It was not tagged together, Lordship.
Oh, not dealing. Okay. This is matter on
A week, Lordship.
when?
10 days time will be granted, Lordship, will make the compilation.
Okay, it's on 13th this November.
13.
Yes.
Both the PIs, there are 3 PIs.
Other matters same.
Lordship,
This
same.
together.
Same. I'll put in a single compilation.
Hmm? Boleh? Boleh. Mata nak buat chief on the scene. We'll fix the time.
Item 65.
Please, Your Lordship, I'm
Yes.
praying for some accommodation, Lordship.
And again, Dr. Mercy, overburdened. Yes.
May 2024 still not complied, my lord. They are making the file run from one office to the other. And finally, they might say that you file a fresh writ petition.
No. The cipher.
Cipher, my lord. Even MHA had cleared the file.
Yes.
Then still, my lord, as I hear, my lord, the matter is still under process.
Yeah, but last time we'd given this thing, this 5th June 2025, implementation order date 28th August, so and so, and order dated 1st May. What happened?
Lordship, as per the last communication we've supplied Lordship on the 7th of August, the matter is under consideration in the Ministry of Finance.
What consideration? You listen after 1 week, yes. You take instruction. Yes. Though instructions had been furnished to this court, more particularly communication at 5th June 2025 with regard to implementation of the judgment and order dated 1 May 2024, passed in WC number 61, 2024. Today also the Learned Council doesn't have specific instructions with regard to progress of the same stuff. Just after 2 weeks is expected to get specific instructions be received. Are they implemented or not?
Not.
Yes.
66.
Yes.
Similar prayer in this matter, Lordship.
What is this?
This is the extension of the tender.
You're already out.
Lordship, no, it is still.
When the tender expiring?
26 to come.
When?
After a week.
2 weeks, Lordship.
Why? 2 weeks?
Lordship.
Yes. List the request on the request also is after 2 weeks.
68. You
told them where is the petitioner, Mr. Rinja? Now he's disappeared himself. You have no objection for adjournment?
No objection, Lordship.
Yeah, they made a prayer, so after 2 weeks, on the prayer of the petitioner. Yes, meet in the morning.
69.
Yes. Who's the petitioner?
Lordship, it is Mr. Estapa.
Where's Mr. Estapa?
He was just here.
You ready with the matter?
Your Lordship, we are ready, Your Lordship.
Yes.
Our role is limited. State.
They are also private respondents.
Yes.
Yes. Branch. This is what matter regarding freezing of account.
Freezing of bank account, Your Lordship.
Yeah, for number 9.
We are for the state
For the
response.
state.
Yes.
Yes, MS Khatun. No, I understand, but have they been? What about this? Your account's been frozen.
Yes, Lordship.
You don't know anything about the case. Okay, list after 1 week. Yes. On the request of petitioner.
71.
Obliged.
So everyone deserted you. Mr. Chanda also is not here. He's all stationed. Yes, after 2 weeks on the prayer of the petitioners.
74.
May it please your lordship. This is the case, my lord, where I have challenged, my lord. I have made two clear. I have challenged, my lord, deputation of private respondent, my lord, in the post of chief academic officer. To which
It's
my
now
promotion
over.
was-
Now
The matter is over, your
No, my
lordship.
lord, let me complete, my lord. I'm
Okay.
saying that now they have filed recently after the argument was advanced, my lordship asked them to file an affidavit. They filed an affidavit, good sense prevailed. They have reverted
Yes.
back the private respondent.
Right.
This is one part. Other part, my lord, was to consider my promotion. Now they have made a statement seeking permission of this court to constitute a DPC matter. That is also fine, my lord. Only thing, my lord, my promotion was due for last 1 year, your lordship.
It's not the
Let
right.
them do it expeditiously, within a time frame.
We not see anything. Yes, in view of the notifications produced by Leonard EAG, where's the notification?
Notification dated 28th October.
But this is an annexure
A of
page
my
5.
affidavit.
Page 5.
Where's, sorry, wait one second. Page
5, Your Lordship, of my affidavit.
in view notification issued by the respondents. It's 28 October.
280.
20 October 2025, whereby
Respondent number 12 has been reverted back.
number 12 has been reverted
To the
parent department. Stop the grievance petitioner on this count has been redressed. However, Mr.
5, my lord.
SN,
They have paragraph 5. They have sought permission of this.
yes, Mr. Sen submits that as the respondents are to constitute a department provision
Yes,
committee, he prays that directions be issued that the same be done expeditiously. Next paragraph, in view of these developments, nothing remains for consideration in this petition, and the same is closed. However, with regard to the proposed DPC, it is expected that the same be constituted and
completed
expeditiously. Yes.
All right.
Obliged.
Matter stands closed.